Okay, good morning everybody and welcome. This is our Spotlight webinar on mediation, and particularly our topic for today is resolving construction disputes through mediation. The topic today is our fourth in our series of webinars. Our webinars are aimed at placing topical matters and leading industry lights under the spotlight. By way of introduction, I'm Damian James. I act as a delay and quantum expert in the UK, the Middle East and Africa. I supplement my practice by acting as a dispute resolver in adjudications and arbitrations, and also by lecturing with certain academic institutions. I have acted as a mediator in commercial matters and court-appointed disputes in the UK. And I am delighted to have with me today two leading lights in international construction law disputes, but with a particular preference for the mediation form of dispute resolution. Firstly, I'd like to introduce Chantelle Humphries. Chantelle is a practicing advocate of the High Court of South Africa and a member of the Johannesburg Bar. Chantelle's practice consists predominantly of construction and commercial disputes throughout Southern Africa, Botswana, Zimbabwe and England. Chantelle has experience in all spheres of ADR and has been complimented on her practical approach to dispute resolution, as well as her diligence into her turnaround time. I'm also joined by Mr. Robert Evans, which is an absolute pleasure to have you with us, Robert. Robert predominantly acts as an arbitrator, adjudicator and mediator in international and domestic disputes. He began his career as a civil engineer, working for international consultants and contractors in the UK and in Hong Kong. Robert utilises his strong civil engineering background and is often instructed in disputes with highly technical issues as a result. Robert is a CEDA accredited mediator, a member of the Institute of Civil Engineers panel of arbitrators and adjudicators, and is currently chairman of the ICE dispute resolution panel. Robert has successfully mediated a number of remote mediations during the COVID-19 pandemic, using many of the main video platforms, and has provided expert evidence on English law in Spanish civil court proceedings. As I say, today we look at mediation and the challenges it faces, particularly to the resolution of disputes in the construction sector. But I don't want to limit us to construction, as there are many lessons to be learned from disputes in other sectors and in other jurisdictions, so the panelists can just consider that in terms of drawing in there in the answers that they provide. I'm proud to say this is our first Anglo-African webinar, and both our guests have experience of complex judicature in not only their own jurisdictions of practice, but also international jurisdictions. Mediation can clearly have a positive impact on the settlement of disputes, and it is said to avoid the Armageddon of arbitration, which both in time and costs, and does offer a cost-effective resolution, which when accompanied by the mediator role can also resolve historical issues and allow the parties to engage in a positive future. Global focus on economic recovery requires investments into many sectors and, of course, requires a successful delivery without prolonged costly disputes. The stimulus is required at a time when lockdown measures, social distancing and the world of virtual working has led to a decrease in personal interaction, and that may be causative of more disputes. Importantly, though, for success of economic investment and the solvency of many companies, not only does the sector need to improve in dispute management, but it needs to provide confidence for those investors to allow greater confidence for future and continued investment. I ask myself whether costly dispute resolution no longer has a role, and I want to put this to our panelists. I'm going to ask the questions. If you have any questions yourself, then please place them in the chat and we'll take them at the end. Hopefully there will be more testing and more challenging than the questions that I pose in the next 30 minutes or so. Again, I have the view that certain companies, projects and individuals may see mediation as a soft approach to the settlement of complex matters. And again, I would like our panelists to keep this in mind. Chantelle, good morning. Thank you very much for joining us. If I may start with you. You're joining us from South Africa, and we have chatted previously and discussed mediation in the construction sector. And whilst construction dominates the practices of many of us attending today, the first part of my question is whether, as a barrister or advocate, as you know, in South Africa, mediation is suited to all disputes or more preferable to certain disputes. And just before you embark on your answer, second part of that question, if you may allow me to elaborate a little bit further, I don't want to limit your response to the sectors suited to mediation, but to how mediation can and should be used in dispute resolution. For example, do you see mediation as a final settlement process, or can it be used in an interim or staged approach?
Morning, Damian. Thank you for having me today and for inviting me to speak at this spotlight. I see some familiar names on the participants list, and it's nice to see that people come back and join you again, or are willing to listen to you again, and specifically on this topic of mediation. So in order to answer your question properly, I think it's important to remember that successful mediation or a mediation, is nothing more than an attempt at reaching a negotiated settlement with the help of an independent third party. I recently read an article, and of course there are thousands, not thousands, maybe hundreds of articles on these issues, but this one, and I'll share it afterwards if anybody wants a copy, it's titled Matching Cases and the Dispute Resolution Procedures, Detailed Analysis Leading to a Mediation-Centered Approach. And essentially, the writers conclude the article by stating that in their view, their suggestion is a simplified, user-friendly solution, and that is to begin with mediation in all cases, except a limited number of situations in which mediation is inappropriate. So with that in the background, there are no hard and fast rules which I can read out. There's no list which I can tell participants or people listening when a dispute is or isn't suitable for mediation. There are, however, certain guidelines which parties and legal practitioners can consider in deciding whether or not to engage in the mediation process. So there's no general dispute which I can say is specifically excluded from mediation. For example, I can't tell parties that insurance disputes or rental disputes are or are not suitable for mediation. In my view, every dispute must be considered on its own merits to determine if it is suitable for mediation or perhaps some other form of ADR, or perhaps it's not suitable to any form of ADR and court litigation is the best approach. So for a start, I think parties should commence with identifying and assessing their client or their own goals. For example, does the client want to maintain a relationship with the other party afterwards? Or perhaps it's your goal to set a new precedent, or perhaps the party wants public vindication. Now, once you've identified those goals, then you can prioritize them and weigh them in what is more important, which goal or which outcome is actually more important to the client. You should also consider if there are any impediments which need to be overcome. For example, multiple parties, different lawyer-client interests, power imbalances, which in my view are simply aggravated during any negotiation process. So you have to consider whether mediation can overcome the issue in your dispute. So in a very roundabout way, my answer to your question, to your first part of your question, is essentially that mediation is suitable for most disputes, except in certain instances where a party's need to attain the result is a result which only a court or an arbitrator can provide. Or, for example, if the dispute turns on a matter of principle. So essentially, I'm really sorry, but I can't give you a list and tell you which disputes are or aren't suitable for mediation. And in my view, each dispute needs to be determined on its own merits. So your second question, I think you asked me at which stage you can use mediation. So mediation is a very flexible process, and it can, in my view, be slotted in at any time during the dispute process. However, there are some obvious benefits if you commence your dispute resolution process with mediation. For example, the matter can settle without incurring loads of costs. If the mediation fails, then the mediator may be able to give an informed recommendation for another procedure. Mediation can also help clarify issues and disputes. It can provide a party with a reality check. It can help educate the decision makers on the other side. So there's so many benefits to mediation, which doesn't necessarily result in a settlement or in resolving the dispute, but other benefits. There's also nothing wrong or nothing prevents parties from agreeing well into their litigation process to pause the process and to commence or perhaps continue with a previous attempt at mediation. So no, I don't see mediation as a final settlement process, but rather a form of dispute resolution, which, even if unsuccessful in resolving the dispute as a whole, has other benefits for the parties. So I hope I answered those two questions.
You did, Chantelle. Thank you very much. I really like the point that you make about the power imbalance and the struggles, and it's something that I want to come back later on as we've dealt with further issues. So I can move on to Robert now. Robert, thank you very much for joining me today. Great pleasure to have you, and I do appreciate you waiting for us. You have a heavy focus in your practice on dispute resolution. Can I ask you for your thoughts on how mediation is currently treated and considered not only in the UK, but in the international arena? And again, a second part question, and I'm sorry, I don't necessarily apologise. What do you expect for mediation in the UK? And how can international companies look to utilise the mediation process in their contracts? And if I can just give you a quick, for example, do you expect to see mediation ensuring or assisting in disputes being avoided?
Damien, good morning, and good morning, everybody, and thank you for inviting me. I think I'm going to ask a question back to you. How long do I have to answer that? There's a lot in that question, or those questions, but let me see what I can do in a limited time. Starting with the UK, or at least England and Wales, mediation has been positively encouraged by the courts for a number of years, with an evolving law on sanctions for parties that unreasonably refuse to mediate. There are a number of reasons for this, not only the benefit to the parties, which Chantelle has referred to and you've referred to. So those benefits including achieving settlement without the need for lengthy and costly litigation or arbitration. And I just throw in there, not only is there the direct cost and time, but actually it's a big disruption to a business. If key personnel are having to consider documents, prepare witness statements, review witness statements, and then attend long hearings, that can be a massive disruption to a business. And mediation obviously avoids all that. The other aspect, I think, where that mediation is supported by the courts in England and Wales, is that it significantly reduces the burden on the court system. And with that point in mind, I think probably surprisingly, the current pandemic is likely to assist the growth of mediation. The courts have an increasing backlog of cases caused by the closure of courts or restrictions in their use, with often no reduction in the number of cases coming forward, perhaps even an increase. So by using mediation, that backlog can be reduced, or at least settling cases in mediation. And I think this isn't limited to the UK, where some countries have huge backlogs of cases waiting for court. And I think I'm right in saying, I think it's India, no disrespect intended, has a backlog of approaching a decade or so. And I think they are seriously encouraging, or seriously trying to encourage, mediation to ease the burden on the courts. Internationally, I don't think there's any one global answer. A bit like Chantelle, there's no single answer to most of these questions. Some jurisdictions have taken to mediation far more than others. The obvious example is the US, where mediation has been embraced across many sectors. And we're talking about construction, but it can deal with matrimonial disputes, personal injury, you name it, family disputes. You name it, mediation can cover it. And the same is true in the UK as well. But on the other hand, equally sophisticated countries have little or any appetite for mediation. I think I read recently that Germany, for example, has a tiny uptake in mediation, and it's just not supported or encouraged by the courts. I have to say, at the start of this morning, I was very encouraged by the South African new rule. I think it's Rule 41A. Although I was going to say, I suspect the jury is out, so to speak, as to how successful it will prove to be. Talking to Chantelle just a few minutes ago, it appears it's proving to be highly unsuccessful at the moment. But I think Rome wasn't built in a day. I think it's fair to say the UK jurisprudence and law on sanctions for mediation didn't develop overnight. And I think these things have to be given time. And one hopes with time, the courts will support mediation, and that will lead to a growth in it. As to the second part of the question, I think the Singapore Convention ought to be a catalyst for mediation in international commercial contracts. Although when I last looked, I think it's been ratified by a very limited number of countries. I can only hope that that number will extend, and actually that will give more legitimacy to international mediation. That said, and picking up on one point in your question, drafting contracts to include mediation is not the whole solution. As I often say about mediation, you can take a horse to water, but you cannot make it drink. Mediation is a voluntary, consensual process. And just because a contract requires a party to mediate does not mean that it will do so constructively or at all. And I'll give two examples here, which is it's slightly odd. I'm not sure whether this represents a new trend, but in the last couple of months, I've had two appointments to mediate disputes arising out of Saudi contracts with mediation in the UAE. Now, one appointment, the appointment was by agreement of the parties, and no difficulty arises. That's due to take place at the end of May, all things being equal. The second was a contractual mediation, and I was appointed by one of the UAE appointing bodies. There was a contractual time limit for mediation, on the expiry of which the mediation was or was deemed to be terminated, with the parties able to agree to extend that time limit. The party that sought the appointment, the party that didn't seek the appointment, the other party, simply did nothing and waited for the time limit to expire. And it did, and the mediation was then dead in the water. The parties had to move on to the next tier of dispute resolution. And I think that illustrates the difficulty with contractual mediation. You can make a party mediate as a form of dispute resolution, or try to, but if one of those parties doesn't want to take part positively in the mediation, there's nothing you can do about it, and the process is doomed to fail. Anyway, as I said, I'm not sure this is a new trend for mediation in the Middle East, but I certainly saw it as encouraging.
Absolutely.
Thank you, Damian.
Thank you, Robert. That's a fantastic answer, and thanks for the updates in terms of the Middle East as well. Maybe, Robert, you mentioned South Africa there. Maybe we can hop across the ocean to South Africa and look at the evolution of Rule 41A in South Africa into the codified law there. I'm directing my question at you, Chantelle, if that's okay. And a number of issues for me to ask you, really. Has Rule 41A seen a lessening of the traditional litigious approach to dispute resolution in South Africa? And I may just ask you to pause just a second if I can develop my question a little bit further. The construction industry in South Africa and most jurisdictions is proficient at causing disputes, managing the disputes, and ultimately resolving disputes. And we all play our part in that. Where is mediation in construction in South Africa? Are you seeing contracts, as Robert talked to, including a mediation clause, or is it still necessary for parties to agree to mediation? We did talk about other sectors that are suited to dispute resolution by mediation, but what is preventing mediation as a contractual clause within construction contracts in South Africa? So I know that I've asked you three questions there, and I do apologise, but maybe you could just talk us through the Rule 41A and that the traditional litigious approach. Where do we sit now in South Africa?
Okay, so I think you have to remember that Rule 41A only requires parties to consider mediation once they've already commenced with their litigation. So I see we have attendees from South Africa, so I'm sure they can correct me if I say something wrong. But the party is only required to consider the mediation once they have taken steps or once they've instituted their action. So the parties is only required to, at the same time as issuing their action or application, to consider if mediation is suitable. So in my view, that the rule has not reduced litigation, because when the matter has been issued at court, the party has already incurred substantial legal costs. They've already got opinions on their success chances, or they've already spent money consulting, paying the attorney or the advocate to draft the necessary proceedings. And when they've already taken those steps, normally they don't want to immediately settle or consider embarking on mediation because they want their day in court, which is a pity, because at the end of the day, most of the trials end up settling in any event. And the difficulty, in my view, or perhaps why it's been a bit slow in taking off, is because we haven't yet seen the judgments or the courts sanctioning parties who refuse to mediate their disputes. So it's not that the parties are unwilling to consider mediation. I just haven't seen compliance with the rule yet. I haven't seen parties indicating that mediation is not suitable. I just have not experienced parties actually considering mediation. And perhaps some of our panelists some of our attendees can express their opinions or let us know if they've had matters which have utilized Rule 41A and have actually proceeded to mediation. So you asked me whether construction contracts are including mediation. So because most construction matters make use of standard forms, I haven't seen many specifically include mediation. So they normally mention amicable settlement period in which the parties are required to try and negotiate a settlement themselves. And then most, if not all, of the standard form of construction contracts then indicates that the dispute must go to adjudication and then to arbitration. So if a party wants to then refer their construction dispute to mediation, they normally have to agree thereto in addition to the other dispute resolution mechanism in the contract. So now the next step is, what is preventing construction contracts from including mediation? And I think it is because there are so many other processes already in the standard form of contracts. So you can understand that, or you can appreciate that parties to a construction contract are required firstly to negotiate, then they have to adjudicate, and then only can they go to arbitration. Now they already have to jump through 2 hoops just to get their dispute ripe for arbitration. Then they get an arbitration award and they would then have to perhaps apply to court to enforce that arbitration award. That means a party to a construction contract has to take 4 steps before they perhaps see any money. So they have to embark on 4 processes before they can force the other party to comply with the arbitration award. So now to expect parties to also consider mediation, which is a further cost, because they then have to pay the mediator, they have to pay the adjudicator, they have to pay the arbitrator, and they have to apply to court. I think that's asking a bit much of parties to a construction contract. So my suggestion is perhaps that parties should consider, or perhaps there should be a new consideration to replace the negotiation element in the construction contract with mediation. Something you mentioned in your opening comments, Damian, that people consider, or parties consider, mediation to be soft. In my view, that is simply because they have a fear of the unknown, perhaps. Perhaps they're not educated on the benefits of mediation, as I expressed earlier, for example, clarifying the disputes, etc. And I've also heard that there's a fear amongst legal practitioners in South Africa especially, that if they recommend mediation to their clients, firstly, they'll lose a substantial amount of their fees, or worse, in some instances, the clients might lose faith in their lawyer's ability or willingness to fight for them. If you're recommending to a client to enter into a soft approach of a settlement discussion or mediation, the client might consider you to be unwilling to fight for them, which would result in a loss of faith in the legal practitioner. So because of these things, I simply haven't seen construction or parties to a construction contract embracing mediation yet. But we're hoping to change that with educating parties on the benefits of mediation.
Thank you very much, Chantelle. From what I understand you to be saying, and this will dovetail nicely into the question that I'd like to put to Robert, the legal process, the contractual process, and to some extent a lack of awareness of the parties to a dispute is possibly stymieing mediation in a South African context. And when we think of how that can be changed, I mean, I'll come across to you now, Robert. We have seen a plethora of mediation over the last immediate period in the UK. And with that, we have begun to see more and more case law in the UK in respect of mediation. Most recently, I looked at DSN versus Blackpool, which contained a heavy condemnation of the parties in respect of costs. Do you think that other jurisdictions will learn from the UK courts quickly? And what lessons do you think they can learn? And maybe if I can ask a third part question to that. Do you think the evolution of mediation will take a long time to work itself into some of the traditional legal systems, such as the South African one that Chantelle has just talked to there?
Thank you, Damian. Can I just, before I answer that question or those questions, pick up on something Chantelle said? It's right, parties are concerned when they go into mediation as to what they're going to get out of it. But actually, I always say that a good outcome in mediation is one where both parties, or all parties, if it's a multi-hander, all parties are equally unhappy. And actually, it's surprising how often that's the case. And they're not, but often not only they're unhappy, they're actually quite relieved. They can get on with their lives. They can put the disputes behind them and move on. And that's the beauty of it. Often at an early stage before costs have become a real bar to settlement. Anyway, back to your question, Damian. Can I take the sort of first two parts together, if I may? You mentioned DSN and Blackpool Football Club. For those that don't know the case, and very briefly, the losing defendant, which was the football club, refused to take part in settlement negotiations, not even mediation, settlement negotiations, because it believed it had a strong defence. Should perhaps pause there. The court had ordered the parties to consider taking part in ADR and settlement negotiations, and if they weren't willing to do so, to explain their reasons for not doing so. A bit like Rule 41A, I think. And the defendant said it believed it had a strong defence and that it wasn't appropriate to take part in settlement negotiations. Anyway, of course, it lost the defendant, so its defence wasn't that strong. But the court said that this behaviour was unreasonable and awarded the claimant its costs on an indemnity basis, so at a higher level of costs. Now, it has to be recalled that the English or England and Wales jurisprudence on sanctions for failure to mediate or at least consider mediation and or ADR has developed over many years, 2 decades or more. No doubt its development has mirrored the increase in the amount of mediation we've seen, or perhaps it's the other way around. And the two, they're now well respected. Practitioners and their clients clearly understand that there are sanctions if they don't or if they unreasonably refuse to mediate, and as a result, mediation is becoming fairly mainstream. That said, and picking up again, sorry, on one of Chantelle's points, it's not right for every dispute, and the courts are aware of this. It may be that there's a legal precedent, or it's simply not appropriate for that particular dispute. So the courts don't look blindly at a failure to mediate. They will look at the reasons underlying it and whether they are reasonable or unreasonable. Turning to other jurisdictions, will they learn? I certainly believe it's in the interests of nation states and their legal systems to support mediation. I mean, there can be no harm in doing so. No party is compelled to go to mediation and reach a settlement it doesn't want. As I said, you can't make the horse drink. So there's no downside to it in many respects. Costs are relatively modest normally compared to the cost of the dispute. Now, how will this develop? I think countries will develop their own principles or learn from others, such as the UK. A good example of this actually is South African Rule 41A, where they've come up with this rule of court. I appreciate it's not being used yet, but where they have very broadly said, well, we'll look at behaviour when we come to consider costs. I think I'm right paraphrasing. They haven't put down any hard and fast rules. Now, whether they develop their own rules along the lines of the UK system, or perhaps something far less stringent, so that there is less of a sanction, we'll have to wait and see. But it's certainly encouraging to see that, I think, as you mentioned, Damian, as a starting point. As to the speed, again, I think the South African lesson is both very current and very topical. I think inevitably change will be incremental, and the speed it works through, if at all, will vary largely between states. I mean, South Africa has a developed legal system, but here we have parties effectively ignoring their obligations under the rules of court to actually consider mediation and to address it. It's up then for the courts to take the lead and actually start sanctioning parties. Anyway, I think you asked, what can the parties learn from the UK or other developed mediation jurisprudence? I think what they can learn is that sanctions do work and do encourage parties to mediate. And hopefully alongside that, they'll realise that mediation is, or can be, an efficient method of resolving disputes and reducing the burden on national courts.
Okay, thank you very much, Robert. I think that's an insightful answer. I think obviously it dovetails nicely with Chantelle's point in respect of Rule 41A, and maybe the need for sanction at some point in the future, just to act as a catalyst to the mediation process in South Africa through the court system. But obviously time will tell on that. Chantelle, we are in a virtual world, and maybe we are beginning to ease our way out of it, but the virtual world will probably stay part of our lives. Just turning to actually the conduct of mediations, and given the very nature of mediation and the salami slicing between parties, my experience of mediation has been shuffling between rooms in Regent's Court at times. Do you think the use of a virtual platform limits mediations, or in the alternative, does it provide a stimulus for parties to resolve their matters because it's available and it can be carried out at 4 o'clock in the afternoon? What are your thoughts on the virtual platform? Is it here to stay?
Yeah, so quite interesting. I think that we can all agree that by the use of virtual platforms, everyone has suddenly become accessible. Previously, a consultation, meeting, or interview had to be arranged days, weeks, maybe even months in advance, especially if it involved traveling. Now, parties seem to have a meeting about everything, and they can quickly agree to have a quick meeting tomorrow at 2 p.m. because they won't have to leave their offices or even leave their homes to attend the meeting. So I personally have not conducted a mediation virtually. I've had adjudications, arbitrations, and loads of court matters run on virtual platforms. And as I said, I certainly feel that dispute resolution processes have become more accessible to parties, and perhaps even a little bit more cost effective, because there's no venues, there's no expensive recording devices to be used, because Zoom records and Teams can record. So perhaps there's been but perhaps there's been a cost saving by the use of virtual platforms as well. The only aspect which I'm uncertain about, and I think actually Robert may be better positioned to answer this question, is that I'm not sure if mediation requires a bit more of a personal touch or personal involvement, a bit more of a connection between the mediator and the party to gain the trust of the party, and perhaps that is not perhaps that's not achievable virtually. I don't know if the attendees has any comments on that, but I feel that if you want to, for a mediation to be successful, you have to trust your mediator, because you have to tell your mediator confidential things so that the mediator is in a position to understand your needs and the goals and what you actually want to achieve in this mediation. And again, I'm not certain if that can be achieved virtually. But as I said, I think Robert might be better positioned, and you, Damian. I think you said you might have done a mediation virtually. I'm not sure, but perhaps you two could give your opinions, because I don't think I'm entirely qualified to answer this question.
Yeah, well, I think the important point you make is that for some parties, the virtual environment may make mediation more attractive, insofar that it's worth trying, even if you are fearful of the process and it doesn't give you what you want. During this pandemic situation of using the virtual world and the courts being backlogged in terms of the caseload, etc., maybe mediation is worthwhile. So maybe the virtual scenario should continue, and maybe it will help in terms of catalyst encouraging people, and definitely from an awareness point of view. Maybe I'll come back to that shortly, Robert, but if I just want to pick up on your experience as a civil engineer and your work across the world prior to your morphing in your second career as a dispute resolver, so to speak. We've seen in all our contracts, the contracts that you and I will have been familiar with, the World Bank relies heavily on the use of heavily modified contracts. Sometimes the special conditions are thicker than the FIDIC conditions. Do you think it's possible for these contracts to use mediation and for the employer and the contractor to both feel adequately protected? And obviously a second part on that again, then taking your experiences in disputes across the world, what are the common reasons, as you see it, that parties consider mediation as a form of dispute resolution? And then finally, you did touch on the Singapore Convention, so I just want to introduce that back into this question if I can. How do you think the Singapore Convention, do you think it's capable of supporting mediations between international parties in the future? Do you think it can develop to such an extent that there will be protection to parties, as I've talked to in the first part of the question?
Damian, thank you. Before I answer that, if you don't mind, can I just come back to Chantelle's point about virtual mediations? Because I think it's important. I mean, we don't know how long we're going to have our hands tied. But I've done, since the lockdown in the UK started, so March of last year, I've done a lot of virtual mediations. I should say, right at the beginning, I did a telephone mediation, which was a complete disaster, but I'd never tell anybody about that. I don't recommend telephone. But the virtual ones I found them to be very, very successful. Now, Chantelle touches on the really important point. Mediation is often about soft skills and building trust and rapport with the parties. And that to some extent is lost. But you can still build the trust. I mean, I did one yesterday. It takes a while, perhaps a little bit longer. But you can do so. And of course, there are many huge advantages. Chantelle touched on these. People don't have to travel. I did one, a co-mediation with two parties, but each party was a joint venture of 4 companies. Some were in Spain, some in the UK. Worked brilliantly. People didn't have to travel. People could fit in around the time differences and so forth, which were very modest in that case. There are a lot of advantages. So I would certainly not be put off as a party or a mediator or a party's advisor to virtual mediation. I think it can be as successful. I've certainly probably had a better run with virtual mediations than I've had with real world ones recently, but I think those things just go in cycles. But yeah, there are some disadvantages, but a lot of positives still from virtual mediation. Now, I'm sorry for that diversion. I'll try and very quickly take the question. I think you started about contractual mediation. I've already mentioned my perceived problem with contractual mediation. You can take a horse to water, but you can't make it drink. But actually, in many respects, that's one of the protections that is inherent in mediation. If a party is compelled to mediate, It can either not take part at all, quite frankly, or can do so grudgingly. But it is never compelled to achieve a settlement that it doesn't want to. The settlement is always in the hands of the parties. So if a party is unhappy with what's on the table or any alternatives to it, and is happy with the alternative to settlement, which is going down the other dispute resolution process, then it can always walk away. So to that extent, the party has the ultimate protection. Other protections, I think contracts can be drafted so that the parties have reasonable time limits. They're not sucked into a mediation, which is going to delay the dispute resolution process for a long time. And invariably, there'll be a time limit followed by other dispute resolution processes. You can't have mediation as the sole dispute resolution process. Ultimately, if the parties can't agree between themselves, you have to have a decision maker who will decide the dispute, whether it's DAB, arbitration, or litigation. So that's the key thing in protections, I think. As to encouraging parties, the most important thing, in my view, is experience of mediation, positive experience. If parties or their advisors have positive experiences, if they understand the process in action, that can only be good and hopefully lead to greater familiarity and then use of mediation. As to the second part of your question, I think, Damian, if I remember it right, parties consider mediation because they or their advisors understand the process and the advantages to it. That's really the point I've just made. I mean, you mentioned the Singapore Convention, and I think despite its low take-up so far in terms of ratification, I think it should be a real force for good for mediation. I think it adds a greater level of legitimacy and confidence in mediation in cross-border disputes, because it shows the international community supports it. And of course, it'll remove one of the concerns parties to international mediation mediations have, which is difficulty of enforcing a mediation settlement agreement if they reach one. So that's all a power for good.
Thank you very much. Chantelle, if I can come back to you, maybe a little bit more of a thorny question as we sort of move into the close and some questions from the audience. What are your thoughts on the process of lawyers, attorneys, and experts in mediation environments?
Damian, I feel like answering all your questions with, I don't think there are any hard and fast rules, and I don't have an answer to your question.
What are your thoughts, though, on those processes? Do you think it'd be conducive to settlement, or do you think it would be obstructive?
Yes, so I think, again, that in some instances, lawyers might be very helpful in mediations, and other times they might serve as an obstacle. So you must remember that most clients, hopefully, have faith and trust in their lawyers. And this can greatly assist the mediation process if the lawyers are taking an active role in promoting and assisting the mediator in the mediator's role. So, you know, just because mediation is flexible and perhaps more informal than other processes doesn't mean it's not a process. Mediation is still a process for the parties to go through. And a lot of parties will feel uncomfortable attending that process without having their legal advisor present. So I think that, you know, in some instances, if the lawyer does not believe or promote or is fearful of mediation, that could be an obstacle to the mediation being conducted successfully. In regard to experts and mediation, I think it's a little bit more complicated because the mediator is not making a decision. The mediator is not enforcing a decision on the parties, but rather assisting the parties in resolving their own disputes. So the expert's traditional role or duty to the tribunal, for example, falls away because the expert is not delivering a report to assist the mediator, because the mediator is not going to make a decision. the mediator, depending on which process, which mediation process, but the mediator is not going to make a recommended settlement for the parties. It is for the parties to reach the settlement. So, you know, if the parties agree before mediation on the use of a single joint expert, that could be useful, because that expert's report could be the starting block for the mediation. It could be the reality check that one of the parties needs, especially in a construction matter, that this dispute should be resolved and is not necessary to go through adjudication and arbitration for the party to get a little bit of money and for the other party to get a little bit, or to pay a little bit less. Again, I think it's a case-by-case basis. You know, in construction disputes specifically, I think that experts should be engaged earlier. I think that you should have your expert on board from the get-go, so that the expert can give the client some time, especially if it's a good independent experts, like all experts should be, but give the party the reality check that they need. Tell the party, I know your claim is for £10 million, but you can only substantiate £2 million. And I think that in that instance, the expert might play a role in a mediation.
Okay. Thank you, Chantelle. I know we have some questions coming through, but I just want to put another question quickly to Robert, and time dependent, maybe one or two other questions. Obviously, Robert, you're an experienced mediator. What are your thoughts on mediation as a process? Do you look at this in a process that talks to the past or focuses on the future? Should it always remain available as an option to a party, even though it's an arbitration? The benefits, the risks of mediation. Where do you sit with the different types of mediation? Because we have more brands of mediation coming through. We have facilitative, we have evaluative, and we have arbitration mediation, which is the one that I've heard of late. Where do you sit with these processes? Do you develop, or do you change? Do you move between the processes? What's your preferred?
Damian, firstly, I favour facilitative mediation. So that's when the mediator's not deciding anything, he's simply helping the parties reach their own settlement. Of course, you reality test, you test each party's strengths and weaknesses of each party's case, but you don't in effect decide anything or take sides. But one of the strengths of mediation is its flexibility, and the process can be tailored to the dispute and to the parties. And actually, if I can just pause there, if you forgive me, I keep doing this. Chantelle mentioned there's no single answer to any of these questions. And she's absolutely right, because every mediation is different. Every dispute is different, and the parties are different. They're people, the decision makers, ultimately, whether it's a corporate party or individual, are people. And they're all different, and they have different fears, different concerns, different needs. And that's the beauty of mediation. You can tailor the process to the dispute and the parties. So that's my first point. Secondly, the other great strength is that there is no limit to the solutions that are available. If a party brings a claim in arbitration or in the courts, the tribunal will usually give them some or all of what they're asking for, which is normally money. Mediation can look at novel solutions, solutions outside the box that don't involve payment of money or involve something as well. I can give a couple of examples of recent mediations. One I did, actually not so recent, that one, but the settlement was based on, it was a defects case, settlement was based on the supply of replacement roofing materials by one of the parties. Fantastic. And another one, part of the settlement, one party was going to supply marine fuel to a ship anchored in the Gulf somewhere. These are real win-win outcomes for the parties, because it adds value, it creates value. One party can supply roofing materials far cheaper than the other can buy it. So really novel solutions. And that's why I think facilitative mediation is of assistance. if you get into evaluated mediation, you start to bypass and lose the option to look at those novel solutions and think outside the box. Just picking up on another point you raised, I think mediation can and should look to the future, and that's where these solutions come into it. But inevitably, one must have an eye, on, at least in part, on the past and the underlying dispute. That can never be ignored. The benefits are, I hope, fairly obvious, and since it's a consensual process, excuse me, as I've said before, it's always open to the parties to walk away if they don't feel that the mediation is going in the right way. But because of that should encourage parties, as I said before, nothing to fear of mediation, and to take part in the right positive framework. As to the risks of mediation, I often feel parties have a fear of giving away too much. It's obviously all without prejudice, privileged, confidential, but parties like to keep their cards close to their chest without giving away too much of perhaps their weaknesses or their strong points. But again, as they gain confidence and trust in the mediator, and it does happen, as I said, over virtual platforms, they do start to open up, and that's when the process can really move forward. You mentioned MED-ARB and, of course, evaluative mediation. As I said, I'm not a great fan. I have been asked by the parties on several occasions to, at the end of an unsuccessful mediation, they've said, can you write your opinion of what you think a fair settlement would be, not what the outcome would be, but what a fair settlement would be. And I've done that, and I think that's ultimately led to a result. The other one I did, which was very strange, and I was very reluctant to do, the parties wanted me to give an opinion on the merits, series of claims set out in a schedule, we've all seen them, payment claims, before the mediation. Now I said, I'm not keen on that, because the mediation will just turn on, will look on, each party will look on the ones that I've gone their way with. But they insisted, and I did it. And actually, it's not something I'd encourage, but it did end up with a settlement. I think those are illustrative of how flexible the process is, and how it can be tailored to what the parties want. I hope that answers that question, but there's never an easy answer.
No, absolutely, very insightful, and I appreciate you talking to facilitative, evaluative, and arbitration, mediation, arbitration. So I'm sure everybody appreciates that. I definitely did. Maybe it's time to take some questions, and maybe if I can direct the first one to you, Robert, while you are still on the box, so to speak, and it's from Cecil Gilbert, who I know is an actual practicing mediator. He asked the question of, what is your success rate in achieving a settlement in mediations?
I'm not going to say, and I don't think any mediator ever would. I don't think mediators, well, actually, I have seen some that sort of put in figures. It always surprises me how high it is. I mean, it's, as I said, leaving aside the telephone one, since lockdown, it's at a very high percentage. I'm not going to say what it is. Now, whether I've just been on a good run, who knows? And there are some cases that are simply unsettleable, and you can see that. But actually, even the ones that you think are settleable, they have very sticky patches. You can work through it. And I have an expression, never be surprised as to what happens next, because you can think all is lost, and then all of a sudden something will come out of the woodwork. But I'm not going to, I'd never publish my figures. I think it'd be slightly invidious if it became a sort of league table of mediators. Success rates. I hope you don't feel I've ducked the question, but I think it's a phenomenally successful process. It's not going to work every time. It's not suitable for every dispute, but it can really bring benefit to the parties in bringing their disputes to an end.
Okay, just keeping with that, because I think you answered this question rather eloquently previously. Uwe Pulitz asks us, where the parties participate but don't agree, can the mediator offer a possible solution having insight into the background with the proviso that she cannot be held responsible if accepted and not successful?
Yeah, I mean, I've sort of touched on this. Whenever I've given, as I said, I tend to go for facilitated mediation. I think that's, I don't know whether it suits my style or the construction work particularly. I don't know. I suspect it's good for construction because parties always know they've got alternatives. If it doesn't work out here, it might be adjudication or might be arbitration or off to the courts. There's always somewhere else they can go, unattractive as those are. I think it's important that if you are going to, as a facilitative mediator, if you are going to delve into the arena, so to speak, you need to make it clear to the parties what the ground rules are and when you do that and how you do it. The ones that I have actually given some sort of view, I think, have generally had written into the mediation agreement what I would do. So I mentioned the one where at the end we hadn't settled, but they asked for my opinion on a reasonable settlement. That had been written into the mediation agreement, so I knew it was coming if we didn't reach a settlement. I'm not sure, has that answered the question?
Yeah, I think so. I think that's a helpful answer. I appreciate that, Robert. Maybe I'll just come back to Chantelle now, just so we can get through some of these questions. Christopher Darby-Lewis has made a couple of comments, both in the chat and the questions. Chantelle, I could just direct these towards you. One of the notes that Christopher makes is that he thinks that the legal fraternity is apprehensive to using mediation, adjudication, and arbitration. And I guess Christopher suggests that there's they favour the litigation process, and rather maybe not on a cynical basis, but maybe that helps with the pillars of justice. However, Christopher also talks, if your mediator is an expert, he will have the beneficial knowledge needed to probe by asking the right questions in trying to get parties to come to settlement. An attorney can utilise an expert, his capacity on a consultative basis to gain an informed opinion. Where do you sit with that, Chantelle? I think it was very much in line with what you had suggested in your answer to my previous question.
Yes, so firstly, I think on his comment it says the legal fraternity is apprehensive to using mediation, adjudication, and arbitration. I'm not sure if that means that they are hesitant to use all three, or they're just hesitant to ADR in general. But in regards to mediation, it would appear that they are hesitant because, as I said earlier, not only are they scared of appearing soft to their client, but they also don't want to lose out on any possible fees. I certainly don't think that lawyers are scared of using adjudication and arbitration. That's predominantly what I practice in, is adjudication and arbitration, and we're forced by construction contracts to use that process in any event. I think the second one was if your mediator is an expert, he will have the beneficial knowledge needed to probe by asking the right questions and trying to get the parties to come to a settlement. I agree with that. I think, again, it is dependent on the dispute, whether or not you use an expert as opposed to a lawyer, or whether some disputes are more suited to the use of a lawyer. I think you'd also see that in arbitration tribunals, they, if it's a 3-member tribunal, you would see that perhaps 2 are lawyers and 1 is a expert or a technical person, and that is extremely helpful. I'm not sure if we're going to see that with mediations, because that would end up being quite expensive. But it again depends on the dispute, because I think Robert mentioned earlier in the USA they embrace mediation, especially in family law. The same in South Africa. Mediation is very popular in family law. But if we deal with construction disputes, some disputes are very technical in nature, and perhaps then an expert is more suited. Other disputes might revolve around the interpretation of a contract, or a dispute on what this provision means. Then perhaps an expert is not better suited than a lawyer. Then perhaps a lawyer is better suited, because the lawyer can then ask the right questions. So again, I think it depends on the dispute, whether or not an expert or a lawyer is the more suited mediator.
Okay, well, maybe we can ask our other mediator on the call. Robert, you obviously, no doubt an expert in civil engineering, no doubt that, and obviously acting as a mediator. There's a question there, or not so much a question, but Christopher says the court has the latitude to request a summary opinion from the mediator. So let's put you in the environment of being a civil engineer, mediating a dispute between two international companies, you using your expertise. Where do you sit in terms of that request for a summary opinion from you as the mediator?
Yes, Damian, I saw that question and I was rather hoping it wouldn't come my way, because I'm not sure whether we're talking about South African jurisdiction or elsewhere. But certainly one of the sacrosanct principles of mediation is that everything done or said at it is privileged and without prejudice, and it's never going to, in theory, never going to get back to the courts, and that's one of the strengths of mediation. So I'm not sure where the question is the court would ask the mediator for an opinion. I've certainly not come across that, and it's not something I would want to get involved in, I have to say, but perhaps I've misunderstood the point.
Okay. If your two parties didn't settle in an international arbitration on a civil engineering dispute, and obviously as an expert in civil engineering, what would you look to provide an opinion, a summary opinion in respect of maybe technical parts of it, or would you just leave the mediation as a closed forum?
I'd be very reluctant to give too much of an opinion. The difficulty is, I mean, if there's Chantelle mentioned different types of disputes, so maybe a point of interpretation. Yes, I could deal with that. But as soon as you get into factual issues and technical expert issues, it's really difficult, because you don't know all the facts, you don't know all the technicalities, and I think it's very dangerous then to start assuming you do and deciding one way or another, or giving an opinion one way. So I think that's very dangerous territory. As I said, I've done these two disputes where I've had to form an opinion on merits in one beforehand, and the other, which is I've done a few times, an opinion afterwards. But those, I mean, opinion on a reasonable settlement is far different to an opinion on the merits.
Okay. Chantelle, you have your hand up.
Yes, Damian, I have to agree with Robert there on Christopher's question or comment, and perhaps he could, email me afterwards or something. But I don't think the court has the scope or the power to request an opinion from a mediator. Whatever happens in the mediation is confidential, and it is not to be used in litigation. It cannot be used in litigation. That is the entire process. That's the entire purpose of mediation, is because it's confidential. And what you tell the mediator, he cannot tell the other party without your consent. So if you tell the mediator, look, my bottom line is 100 Rand, that mediator is not entitled to disclose that to the other party. And in fact, that mediator should destroy all his notes on this mediation when it's finished, because the mediation process is confidential. So I disagree. I have not seen anything in South African courts that allow the court to ask a mediator for the mediator's opinion. I think it's different if there are children disputes and if you have social work or something, but certainly not in commercial disputes. Damian, I'm sorry, I know that I'm talking a lot, but I just quickly want to answer this other question as well, if that's okay. There's a question that says, JBCC standard form contracts since 2017, 2014 have included mediation as the first step before adjudication and or arbitration as a mechanism to resolve a deadlock in adjudication or arbitration. JBCC is probably the most used standard form contract in Southern Africa. I think that's a matter of opinion. I certainly don't think JBCC is the most standard form contract used in Southern Africa. In fact, I have only had maybe a handful of matters with JBCC. I think FIDIC and NSC are much more popular, or a lot popular in South Africa than JBCC. And also what Robert said earlier is that you can take a
Horse to water.
But you can't make a drink. So the fact that the contract includes mediation doesn't mean the parties actually embrace it. In fact, my experience is that they just amend the contract, the standard form, and take mediation out of it. So I'm aware of the JBCC form that it has mediation in it. Parties either just tick box it and say we tried, it didn't work, or they just write it out of their contract. There we go. Just had to get that in there.
Okay. Well, thank you. We don't have any more questions. I mean, there were two topics that I just wanted to cover, and maybe I can just voice them. And if you would like to say anything in response, that's great, and we'll conclude at that point of view. One of the issues that I have is the topic that you picked up on earlier when you talked about the power imbalances and the struggles, and there are people to disputes that basically need to deal with the pillars of justice and almost need to be told by a third party in a court of law what the decision is. They need to obviously embrace and try to engage in mediation as a positive process without giving up that possibility of that future proposition before the courts. The other issue that I read recently is that mediation is the poor relation of arbitration. Well, I think from what I've heard from both you and Robert today, my opinion of that differs significantly from the start of the conversation to the end of the conversation, so I really appreciate that. I think finally we have one question, and it's from Cecil Gelbart again. There is a difference between being a mediator and representing one of the parties in a mediation. What are your views on this? And maybe we can conclude with the answers to this. That'll be fantastic. Thank you both.
Oh, who's going to take it? Oh, I'll give a comment, and Robert can give a comment.
Okay,
yeah, so yes, there is a difference between being the mediator and representing one of the parties in a mediation. So a lot of the times parties prior to agreeing to mediation will also agree whether or not they're entitled to being represented or not. So a lot of parties prefer to have their lawyers present, as I said earlier, and they will then agree upfront to representation at the mediation.
Yeah, I mean, I agree, and it's a very different role being a party representative and being the mediator. I'm not saying you can't do both as within your professional practice. Obviously, you can't do them at the same time, but yeah, they are very different, and you use very different skills. And of course, doing one is good experience for doing the other. I mean, before I became a mediator, I'd done a lot of party representation, and you learn a lot, and you learn a lot about how mediators act and how they conduct mediations. Of course, you only ever see, as a party representative, you only ever see one side of the debate. But yeah, very different. But a good skilled practitioner can do both.
Yeah. Well, Robert, Chantelle, thank you for your time today. I know your time is valuable. It's been an absolute pleasure to have you both with me. I thank you for your attendance, your input, and the lessons that we've learned today have been most valuable. I'm sure that our audience appreciate your thoughts and opinions today. This spotlight will be available on our YouTube site, which can be found via our website page, along with our previous spotlights. Thank you very much to Robert and Chantelle once again, and thank you all for joining us. I look forward to seeing you again at our next spotlight in June. Thank you.
Thank you.
Thank you.